Hello, I'm Aratrika Bhaumik and welcome to The Hindu. In a crucial verdict, the Supreme Court of India on November 25th upheld the inclusion of the terms socialist and secular in the preamble of the Constitution through the 42nd Amendment back in 1976. A bench comprising Chief Justice Sanjiv Khanna and Justice Sanjay Kumar questioned the motives of the petitioners and remarked, and I quote here, the fact that the writ petitions were filed in 2020, 44 years after the words socialist and secular became integral to the preamble, makes the press particularly questionable. This stems from the fact that these terms have achieved widespread acceptance, with their meanings understood by we the people of India without any semblance of doubt. Before we delve deeper into this case, let's quickly revisit the legislative history and politics behind the 42nd Amendment. The terms socialist and secular were incorporated into the preamble during the emergency in 1976, imposed by then Prime Minister Indira Gandhi. The 42nd Amendment replaced sovereign democratic republic with sovereign socialist secular democratic republic. It also substituted the phrase unity of the nation with unity and integrity of the nation. The amendment also introduced changes that limited judicial review, effectively undermining the Supreme Court's 1973 landmark judgment in the Keshavananda Bharati case, which had established the basic structure doctrine. Historians like Granville Austin have documented how former parliamentarians like A.R. Antulle and D.K. Barua were instrumental in including these particular terms in the preamble. While Antulle advocated for inclusion of the term secular, D.K. Barua had proposed the term socialist. Interestingly, Antulle's Muslim identity is historically believed to have influenced his stance on secularism. In 1978, the Janata Party government repealed most of the 42nd Amendment through the 44th Amendment but retained the changes to the preamble. The recent petitions filed by Subramaniam Swamy, Balaram Singh and Ashwini Upadhyay contended that the 42nd Amendment distorted the Constitution's original vision. They also cited Dr. B.R. Ambedkar, who during the Constitution Assembly debates had advocated against the inclusion of these terms, saying, and I quote him here, "What should be the policy of the state must be decided by the people themselves according to time and circumstances." However, the Supreme Court dismissed these claims, reiterating that Parliament's authority under Article 368 of the Constitution extends to amending the preamble as well. The court emphasized that the 42nd Amendment had already undergone extensive judicial scrutiny. For instance, in 1980, the Constitution Bench in Minerva Mills v. Union of India upheld these insertions, declaring them vital to the Constitution's philosophy. Notably, the judges clarified that in India, the term socialism does not refer to any particular economic policy, but instead denotes the state's commitment to the welfare of the people as well as equality, while secularism ensures that the state does not favor or penalize any particular religion. The court also underscored that legislative actions taken during the emergency cannot be annulled merely on the ground that the extended tenure of the parliament was meant only for emergency purposes and was not meant to amend laws or the constitution. This particular verdict is significant as it addresses recent political debates, especially the BJP-led NDA alliance's critique of the inclusion of these terms in the preamble. Thank you for watching. For more such videos, please subscribe to The Hindu.